ಹಲೋ ಎವ್ರಿವನ್, ವೆಲ್ಕಮ್ ಬ್ಯಾಕ್ ಟು ಮೈ ಯೂಟ್ಯೂಬ್ ಚಾನಲ್. ನಾನು ನಿಮ್ಮ ಅಂಜಲಿ ಬಲರಾಮ್. ಈ ವಿಡಿಯೋದಲ್ಲಿ AIBE ಎಕ್ಸಾಮ್ಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಿಂದ ಯಾವ್ದು ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್ ಬರುತ್ತೆ ಅಂತ ನೋಡ್ಬೋದು. ಇದೆಲ್ಲ ಕ್ವಶನ್ಸು ಪ್ರೀವಿಯಸ್ ಕ್ವಶನ್ ಪೇಪರ್ಸಲ್ಲಿ ಕೇಳಿರೋಂಥದ್ದು, ಸೊ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್ಸ್ ಆಗಿರುತ್ತೆ. ಸೊ ಫಸ್ಟ್ ಕ್ವಶನ್ ಬಂದು, ದ ಟೈಟಲ್ ಆಫ್ ದಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ ಇಸ್ ಲೈ ಡೌನ್ ಇನ್ ಆಪ್ಷನ್ ಎ ಆರ್ಟಿಕಲ್ 1, ಆಪ್ಷನ್ ಬಿ ಆರ್ಟಿಕಲ್ 5, ಆಪ್ಷನ್ ಸಿ ಆರ್ಟಿಕಲ್ 390, ಆಪ್ಷನ್ ಡಿ ಆರ್ಟಿಕಲ್ 393. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ ಆರ್ಟಿಕಲ್ 393. So it is the short title of the Constitution of India which is laid down in article 393. Next question, constitutional provisions of fundamental rights are given under which part of the Constitution of India? Option A part 1, option B part 2, option 3 part 3 and option D part 4. So ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಸಿ ಪಾರ್ಟ್ 3. So part 3 article 12 to 35 of the Indian Constitution deals with the fundamental rights. Next question, by which of the following Amendment Act of 1985 anti-defection law was added in the Constitution of India? Option A 51st Constitution Amendment, option B 52nd Constitutional Amendment, option 3 53rd Constitutional Amendment, option D 54th Constitutional Amendment. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಬಿ 52nd Constitutional Amendment. The 10th schedule, popularly known as the Anti-Defection Act, was included in the Constitution through the 52nd Amendment Act 1985 and sets the provision for disqualification of elected members on the grounds of defection to another political party. Next question, in which one of the following cases the Supreme Court decided that a constitutional amendment is a law within the meaning of Article 13 clause 2 and therefore it is, if it violates any of the fundamental rights, it may be declared void? Option A Sajjan Singh versus State of Rajasthan, option B Keshwananda Bharati versus State of Kerala, option C Indira Savni versus Union of India, option D Golaknath versus State of Punjab. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ ಗೋಲಕ್ನಾಥ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಪಂಜಾಬ್. In this case, the issue before Supreme Court was whether the 17th Constitutional Amendment Act, which amended the fundamental right, is valid or not. The court, through its majority opinion of 6-5, observed that an amendment to the Constitution was an ordinary law and not a constitutional law. Hence, the amendment needs to pass the test of Article 13. The court stated that any amendment that violated the provisions of Article 13 would be void. Next question, Uniform Civil Code in India is a option A fundamental rights, option B directive principles of state policy, option C government policy, option D constitutional rights. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಿ directive principle of state policy is the answer. Article 44 of the Constitution of India corresponds with directive principle of state policy and states that states shall endeavour to provide for its citizen a uniform civil code throughout the territory of India. Next question, as per Article 16, no citizen shall on grounds only of dash or any of them be ineligible for or discriminated against in respect of any employment or office under the state. ಇದಕ್ಕೆ ಆಪ್ಷನ್ ಎ ರಿಲಿಜನ್, ರೇಸ್, ಕ್ಯಾಸ್ಟ್, ಸೆಕ್ಸ್, ಡಿಸೆಂಟ್, ಪ್ಲೇಸ್ ಆಫ್ ಬರ್ತ್ ಆರ್ ರೆಸಿಡೆನ್ಸ್, ಆಪ್ಷನ್ ಬಿ ರಿಲಿಜನ್, ಏಜ್, ಕ್ಯಾಸ್ಟ್, ಸೆಕ್ಸ್, ಡಿಸೆಂಟ್, ಪ್ಲೇಸ್ ಆಫ್ ಬರ್ತ್, ರೆಸಿಡೆನ್ಸ್, ಆಪ್ಷನ್ ಸಿ ರಿಲಿಜನ್, ರೇಸ್, ಏಜ್, ಸೆಕ್ಸ್, ಡಿಸೆಂಟ್ ಆ್ಯಂಡ್ ಪ್ಲೇಸ್ ಆಫ್ ಬರ್ತ್, ರೆಸಿಡೆನ್ಸ್, ಆಪ್ಷನ್ ಡಿ ರಿಲಿಜನ್, ರೇಸ್, ಕ್ಯಾಸ್ಟ್, ಸೆಕ್ಸ್, ಡಿಸೆಂಟ್ ಆ್ಯಂಡ್ ಪ್ಲೇಸ್ ಆಫ್ ಬರ್ತ್ ಆ್ಯಂಡ್ ಏಜ್. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ ರಿಲಿಜನ್, ರೇಸ್, ಕ್ಯಾಸ್ಟ್, ಸೆಕ್ಸ್, ಡಿಸೆಂಟ್, ಪ್ಲೇಸ್ ಆಫ್ ಬರ್ತ್ ಆ್ಯಂಡ್ ರೆಸಿಡೆನ್ಸ್. ಏನಕ್ಕೆ ಅಂತ ಅಂದರೆ ನೀವು ನೋಡ್ಬೋದು ಆಪ್ಷನ್ ಬಿ, ಆಪ್ಷನ್ ಸಿ ಆ್ಯಂಡ್ ಆಪ್ಷನ್ ಡಿ ಎಲ್ಲದರಲ್ಲೂ ಏಜ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಆ್ಯಂಡ್ ಅದು ಏನು ವರ್ಡ್ಸ್ ಇದೆ ಅದನ್ನು ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಬಟ್ ಆರ್ಟಿಕಲ್ 16 clause 2 ಅಂಡರಲ್ಲಿ ಏನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಏಜ್ ಬರಲ್ಲ. Next question, the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under Article 143 shall be dash. Option A 2, option B 3, option C 4, option D 5. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ 5 is the answer. Article 143 Clause 3 of Indian Constitution provides that there should be at least 5 judges to hear cases that involve a substantial question of law as to the interpretation. Next question. According to the Article 300A of the Constitution of India, no dash shall be deprived of his property save by authority of law. Option A person, option B citizen, option C foreigner, option D Indian. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ ಪರ್ಸನ್. ಆರ್ಟಿಕಲ್ 300A mentioned that no person shall be deprived of his property save by the authority of law. Next question. Which of the following is not law according to Article 13 of Indian Constitution? Option A rule, option B bylaws, option C customs or usage, option D none of these. ಇದಕ್ಕೆ ಆಪ್ಷನ್ ಎ ಇಸ್ ದಿ ಆನ್ಸರ್ ಬಿಕಾಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಆರ್ಟಿಕಲ್ 13 clause 3 clause A of the Constitution of India, law includes any ordinance, order, bylaw, regulation, notification, custom and usage in the territory of India having force of law ಅಂತ ಇದೆ. ಸೊ ಬೈಲಾ ಮತ್ತು ಕಸ್ಟಮ್ಸ್ ಆರ್ ಯೂಸೇಜ್ನ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ, ರೂಲ್ನ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. ಸೊ ಆಪ್ಷನ್ ಎ ಇಸ್ ದಿ ಆನ್ಸರ್. Next question. Which of the following schedule deals with union list, state list and concurrent list in the Constitution of India? Option A Schedule 7, option B Schedule 10, option C Schedule 11, option D Schedule 12. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ Schedule 7. The 7th schedule of Indian Constitution deals with the division of powers between union government and state government. The division of powers between union and state is notified through the union list, state list and concurrent list. Question bandu. Which of the following writ is issued to enforce the performance of public duties by the authority? Option A mandamus, option B quo warrant, option C certiorari, option D prohibition. ಸೊ ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ ಮ್ಯಾಂಡಮಸ್. ಬಿಕಾಸ್ ಮ್ಯಾಂಡಮಸ್ ಅಂತಂದರೆ ವಿ ಕಮಾಂಡ್ ಅಂತ ಲ್ಯಾಟಿನ್ ವರ್ಡ್ ಇದು. ಸೊ ಲೋವರ್ ಕೋರ್ಟ್ಸ್ಗೆ ಅಥವಾ ಗೌರ್ಮೆಂಟ್ ಆಫೀಸರ್ಸ್ಗೆ ಕಮಾಂಡ್ ಮಾಡೋ ಅಂಥದ್ದು. ಸೊ ಇಲ್ಲೂ ಅಷ್ಟೇ ಪಬ್ಲಿಕ್ ಡ್ಯೂಟೀಸ್ ಆ್ಯಂಡ್ ಅಥಾರಿಟಿನ ಪರ್ಫಾರ್ಮ್ ಮಾಡೋಕ್ಕೆ ಕಮಾಂಡ್ ಮಾಡುತ್ತೆ ಅಲ್ವಾ. ಸೊ ಆಪ್ಷನ್ ಎ ಮ್ಯಾಂಡಮಸ್. Next to 27th question. Which of the following constitutional amendment act had made the provision for publishing in the translation of the constitution? Option A 52nd amendment, option B 54th amendment, option C 56th amendment, option D 58th amendment. ಸೊ ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ 58th amendment. ಸೊ 58th amendment ಆ್ಯಕ್ಟ್ 1987ನಲ್ಲಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬುಕ್ಕ ಹಿಂದಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಏನಿರುತ್ತೆ ಅದನ್ನು ಪಬ್ಲಿಷ್ ಮಾಡ್ತಾರೆ. ಸೊ ಆಪ್ಷನ್ ಡಿ. Next to 28th question. Which of the following is the landmark judgment on the colorable legislation? Option A State of Bihar versus Kameshwar Singh. Option B M Karunanidhi versus Union of India. Option C State of Karnataka versus Union of India. Option D Keshavan Madhava Menon versus State of Bombay. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ ಸ್ಟೇಟ್ ಆಫ್ ಬಿಹಾರ್ ವರ್ಸಸ್ ಕೇಶವ ಸಿಂಗ್. Next 29th question bandu. Which of the following Constitution Amendment Act was passed in light of the advisory opinion received in Re Berubari case? Option A the Constitution 4th Amendment Act 1955. Option B the Constitution 7th Amendment Act 1956. Option C the Constitution 9th Amendment Act 1960. Option D the Constitution 11th Amendment Act 1961. ಇದಕ್ಕೆ ಆಪ್ಷನ್ C is the answer. The Constitution 9th Amendment Act 1960. In this case, it is a legal dispute between India and Pakistan concerning the ownership of the Berubari region in the Jalpaiguri district of West Bengal. Following the judgment of the Honorable Supreme Court, the Constitution 9th Amendment Act 1960 was passed to give effect to the transfer of the territories as envisaged in 1958 Nehru-Noon Agreement. Next question is, which of the following provision of the Constitution of India is relevant for solving questions of repugnancy between central law and the state law? Option A Article 248, option B Article 252, option C Article 254, option D Article 256. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಸಿ Article 254. Article 254 of the Constitution of India deals with the inconsistencies between laws made by the Parliament and laws made by the legislature of states. Next question. What transition period was provided in the Constitution of India for changing official language of Union from English to Hindi? So option A 5 years, option B 10 years, option C 15 years and option D 25 years. ಇದಕ್ಕೆ option C 15 years is the answer. Article 343 clause 1 of the Constitution of India provides that the official language of the Union shall be Hindi in Devanagari script. It took period of 15 years from the commencement of the Constitution. 32 question. In which of the following case it was held that there could be no reservation on single post in the cadre? Option A Chakradhar Pashwan versus State of Bihar. Option B KC Vasant Kumar versus State of Karnataka. Option C AIBE Singh versus Union of India. Option D State of Kerala versus NM Thomas. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ ಚಕ್ರಧಾರ್ ಪಾಶ್ವಾನ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಬಿಹಾರ್. In this case, Honorable Supreme Court had held that a rule of reservation could not be upheld to the single post cadre as it would amount to 100% reservation violating Article 16 clause 1 and Article 14 of the Constitution. Next 33 question. Sexual harassment of a working woman at her place of work may also be considered as the violation of which of the following provisions of the Constitution of India? Option A Article 19 clause 1 clause B. Option B Article 19 clause 1 clause D. Option C Article 19 clause 1 clause E. Option D Article 19 clause 1 clause G. ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಡಿ ಆರ್ಟಿಕಲ್ 19 clause 1 clause G. In the case of Vishaka versus State of Rajasthan, we all know it is a landmark judgment in the area of sexual harassment of workplace. So, in this case, directly violated Article 19 clause 1 clause G of the Indian Constitution affirms the right of all the citizens to be employed in any profession of their choosing or any own trade or business of their choice. So, Supreme Court held that harassment at the workplace is a clear violation of women's fundamental rights guaranteed under Article 14, 15, 19 clause 1 clause G and also Article 21 of the Constitution of India. Next question. Which of the following doctrine has been applied to resolve the conflict between Article 25 clause 2 clause B and 26 clause B of the Constitution of India? Option A Doctrine of harmonious construction. Option B Doctrine of causes omissus. Option C Doctrine of liberal interpretation. Option D Doctrine of pith and substance. So ಇದಕ್ಕೆ ಆನ್ಸರ್ ಬಂದು ಆಪ್ಷನ್ ಎ Doctrine of harmonious construction. In the case of Venkataramana Devaru versus State of Mysore, the Honorable Supreme Court applied the rule of harmonious construction while resolving the conflicts between Article 25 clause 2 clause B and 26 clause B of the Indian Constitution. ಹೋಪ್ ಈ ವಿಡಿಯೋ ಇನ್ಫಾರ್ಮೇಟಿವ್ ಆಗಿತ್ತು ಅಂತ. ನೀವೇನಾದರೂ AIBE18 ಆ್ಯಂಡ್ AIBE17 ಕ್ವಶನ್ ಪೇಪರ್ ಸಾಲ್ವ್ ಮಾಡಿರೋ ವಿಡಿಯೋ ನೋಡಿಲ್ಲ ಅಂತ ಅಂದರೆ ನನ್ನ ಯೂಟ್ಯೂಬ್ ಚಾನಲಲ್ಲಿದೆ, ಹೋಗಿ ಚೆಕ್ ಮಾಡಿ. ಆ್ಯಂಡ್ ಇದೇ ರೀತಿ ಇನ್ಫಾರ್ಮೇಟಿವ್ ವಿಡಿಯೋಗೋಸ್ಕರ ನನ್ನ ಚಾನಲ್ನ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿ. ವಿಡಿಯೋ ಇಷ್ಟ ಆದರೆ ಲೈಕ್ ಮಾಡಿ. ನಿಮ್ಮ ಫ್ರೆಂಡ್ಸ್ ಯಾರ್ಯಾರು AIBE ಎಕ್ಸಾಮ್ ಅಟೆಂಡ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅವ್ರಿಗೂ ಶೇರ್ ಮಾಡಿ. ಆ್ಯಂಡ್ ನಿಮ್ಗೆ ಏನು ಅನ್ನಿಸ್ತು ವಿಡಿಯೋ ಬಗ್ಗೆ ನಿಮ್ಮ ಒಪಿನಿಯನ್ನ ಕಮೆಂಟ್ ಸೆಕ್ಷನಲ್ಲಿ ಕಮೆಂಟ್ ಮಾಡಿ. ಥ್ಯಾಂಕ್ ಯು.